Well, next up, with Israel being castigated multiple times at the International Court of Justice, we're joined by a leading voice in international law. She qualified from Oxford University, clerked for the president of the Supreme Court of Israel in Jerusalem, and she's a sought-after speaker who frequently appears on the BBC, CNN, Fox News, and many other networks. She's also part of UK Lawyers for Israel, a key ally of Stand With Us UK. Joining us from London, Natasha Hausdorff. Thank you for joining us from London. Such a sad day here in Israel. Let's talk about the International Court of Justice and the International Criminal Court. I doubt we would see Lebanon hauled before either court following the Hezbollah massacre against innocent Israeli Jewish kids playing football, playing soccer, and yet we see them coming after Israel so frequently. So can Israel get a fair hearing at the ICJ and at the ICC?
Well, Michael, it's my pleasure to be with you. In the context of which you framed this question, it's impossible to ignore the fact that the ICC is currently presided over by the president of the court, Judge Salam, from Lebanon. He had previously run twice for prime minister of that country, which necessarily involves a connection with Hezbollah in one way or another. And he has himself a vicious anti-Israel track record, not least in the context of his previous position as ambassador to the United Nations, where he voted against Israel over 200 times and accused the Jewish state of being a terrorist, apartheid, engaging in war crimes. So clearly not impartial, the International Court of Justice, that is. The approach that has been taken thus far, and there are two parallel cases proceeding with respect to Israel. One is in the context of South Africa's application, its allegation of genocide against Israel. We have seen a succession of provisional measures orders with respect to Israel, which have been universally misrepresented, in many respects also misunderstood, but have clearly been less clear than some of the orders that the court has put out in other cases, notably in the context of similar allegations that were made with respect to Russia and its war against Ukraine. So when we consider the track record that the court already has, the International Court of Justice, in the context of South Africa's case against Israel, and we also consider the most recent development, its International Court of Justice advisory opinion, a non-legally binding opinion which was delivered Friday a week ago, which rewrote history, purported, it seemed, to wipe Israel off of the map by seeking to recognize what it called Palestinian territory that was contiguous and needed to be respected and preserved as one unit, failing, of course, to recognize the existence of Israel between the West Bank, the Palestinian-controlled territory in areas A and B, and the Gaza Strip controlled by Hamas. When we consider those aspects, then I'm afraid the resounding answer to your question is no, there cannot be any fair trial for Israel in either context in the International Court of Justice. And so far as the International Criminal Court is concerned, well, so far we have seen a decision by the pretrial chamber already a number of years ago when this investigation supposedly against Israel or Israelis was opened that rode roughshod over the court's jurisdictional requirements. And most recently, we have seen an application by the current prosecutor, Karim Khan. We have seen the public summary that he has put out of that application, in which every single statement that was advanced was false. And this was the subject of a submission or an application by UK Lawyers for Israel and some other NGOs that dealt with the inaccuracies of what the prosecutor, Karim Khan, had publicized about his application for arrest warrants against Benjamin Netanyahu and Yoav Gallant. These are just some of the issues, unfortunately, that stand very firmly against either Israel having any sense of a fair trial in the context of the ICJ or any Israelis having a fair trial in the context of the International Criminal Court.
And talking about the ICC, what are the chances that Israel's prime minister or other senior Israeli leaders could find themselves with the threat of arrest?
Well, that depends, of course, on whether pretrial chamber 1 will issue the arrest warrants that the prosecutor has applied for. Since the UK made an application to submit its observations on jurisdiction, those were expected to include observations relating to the Oslo Accords. These Oslo Accords were thrown out of the window by the International Court of Justice most recently, but it's fair to say that any issuing of arrest warrants by the International Criminal Court would also be failing to acknowledge, at a very basic level, the fact that no Palestinian entity has any criminal jurisdiction over any Israelis, so much so that they could delegate that jurisdiction to the International Criminal Court. So the jurisdictional issues that the UK raised in the first instance and have been picked up upon now by many other states, including Germany, the Czech Republic, Hungary, the United States, and NGOs such as UK Lawyers for Israel, that has clearly delayed the process. The hope and expectation would be that that pretrial chamber 1 would properly apply the law and the facts and decline to issue these warrants, not least because there's another important aspect of this that the court has to consider, and that is what's called the principle of complementarity. Now, complementarity is a key aspect of how the International Criminal Court operates, and it requires that where a state that has jurisdiction, as Israel in this case, of any alleged crimes that have been committed in the context of Israeli territory, where a state that is willing and able to investigate any real substantiated allegations of criminal activity exists, then that state should be left to investigate and potentially prosecute any relevant crimes. Here, we haven't even had the end of the war. It is still ongoing. So it's plain that the prosecutor has not given this principle of complementarity any regard whatsoever. It's another reason that these arrest warrants should be going nowhere. I would just add that while we know about the arrest warrant application against the Prime Minister and the Defense Minister of the State of Israel, it is not always the case that applications for warrants are public. Many may very well be made in secret, and we simply won't know about those, or indeed be able to input helpfully to the court to counter the misinformation and the very problematic legal analysis that has underpinned this application, which has been made public.
Very important that countries who value freedom stand against this course of action by the ICC. When you hear journalists in media interviews with you talk about proportionality and stress that Israel is being disproportionate in its response, in its fight back against Hamas, how do you answer?
That it is a complete misrepresentation of what the principle of proportionality requires in international law. It's often presented in the context of comparing casualty counts. Now, not only is that desperately macabre, but it's an incentivization, certainly, to Hamas to increase its casualty count. It's also simply not how international law works. It is illogical. It is abhorrent to suggest that Israel may have been permitted in some way to kill an equal number of Palestinians as those Israelis that were slaughtered on the 7th of October, and that subsequently have been the victim of Hamas and Palestinian Islamic Jihad rockets. No, the principle of proportionality is widely recognized. It is codified in the law of armed conflict, and it requires the reasonable military commander to conduct a balancing exercise to weigh up the direct, concrete military advantage sought by any military action, by any strike on a target or military maneuver, to weigh up the direct military advantage against the anticipated civilian or collateral damage. Now, there's no straightforward formula for that. Ultimately, it's a decision on a case-by-case basis. But the idea that anybody, any media organization or any individual can conduct a proportionality analysis of Israel's actions in the Gaza Strip without knowledge of the military advantage sought by each and every individual strike is laughable. Well, it would be if it wasn't so desperately serious and tragic. It is legally illiterate, and it is part and parcel of a campaign of misinformation about international law, in particular against Israel. This agenda of lawfare, which is an abuse of legal processes and established international law in order to advance essentially the agenda of Hamas here. And it is having a direct impact on Israel's ability to defend itself and its citizens. We have seen the way that the legal allegations, faux allegations, the inversion of international law has impacted the discourse over these issues, has impacted the rhetoric that we have heard coming from close allies like the United States, like the United Kingdom, and inevitably this has directly impacted Israel's ability to conduct its war against Hamas in Gaza in the way that it might otherwise have done.
Now, you've defended Israel passionately, whether it's the monk debates recently with our good friend Douglas Murray or on the BBC and many other platforms besides. What's the most egregious slur that you've faced about Israel, and how do you answer it?
Firstly, Michael, I would say that primarily I see myself as defending the rule of law and the truth and the proper upholding of international law, which is critical not just for Israel, but for any law-abiding states, any individuals that prize the rule of law, especially in the international system. But in terms of the allegations that we've been hearing against Israel, I mean, they are essentially all reflective, unfortunately, of modern blood libels. In that respect, the allegations that we hear of occupation, ethnic cleansing, colonialism, apartheid, genocide, they're all baseless in fact and law, but they also have a particular purpose here. And so in answer to your question, I'd try and sort of lump them together because they, unchallenged, are certainly gaining currency. And the egregious use of these canards, these blood libels, is part and parcel of the lawfare agenda that I was setting out. The latter, the most recent introduction perhaps of this allegation of genocide, the reason that's particularly egregious is because here we are looking at the victims of acts of genocide on the 7th of October that are being accused of the very crimes that were committed against them. And this is a term that was coined by Raphael Lemkin in the aftermath of the Holocaust to provide legal terminology for the genocide that was committed against Jews. It's important that everyone watching understands that the crime of genocide is somewhat unique in that it relies entirely on there being an intention to eradicate a group in whole or in part, an ethnic, religious, racial, or national group. And that is what we saw with respect to Jews being targeted because they are Jews. The abhorrence of this allegation being deployed against Israel when it has gone above and beyond the requirements of international law to prevent civilian casualties in Gaza, when it has done more than any other army in the history of warfare to provide warnings to civilians, to avoid civilian casualties, and to provide humanitarian assistance and facilitate international aid, despite Hamas seeking to divert it and withhold it from civilians in need. In that context, the abhorrence of this false allegation is perhaps the worst that we have seen, but it has been deployed for good reason. People are now saying that they can use Israel and genocide in the same sentence and not be challenged in the way that they might have been before South Africa's application invoking this canard at the International Court of Justice. And that is a perfect example of how they are seeking to shift the Overton window, the parameters of the debate, acceptable debate about this, and the proffering of these false allegations is at the very center of that.
Finally, let's talk about campus. UK Lawyers for Israel works closely with Stand With Us UK with campus students. So for these students, whether they're in the UK, the US, or elsewhere, how important is it to know your rights?
Vitally important, and I'm very proud that UK Lawyers for Israel Charitable Trust has cooperated and coordinated with Stand With Us to produce the Know Your Rights booklet, which is available on the UKLFI website, and highlights to students in the UK, and there are equivalents, of course, for students around the world, the legal frameworks that exist in their respective countries to ensure their rights at university, on university campuses, if they are inviting outside speakers, and to ensure that they know the case that they need to make to the university authorities if they are finding themselves targeted, victimized, or discriminated against in terms of their ability to bring speakers onto campuses to challenge the very important issues that we've been discussing so far, and the developing situation as it pertains to Israel. So arm yourselves with the knowledge, I always say, and the support network is there, both through UK Lawyers for Israel and through Stand With Us. And long may that continue, Michael. Thank you for your friendship and your important support and efforts to ensure that all students on campus know that they are not alone in these extremely troubling times.
So important, and students can go to standwithus.com, look up Know Your Rights, and get that booklet. It's a thrill to hear from you. We appreciate it very much, and thank you for your partnership as always. Natasha Hausdorff, thank you very much.
Thank you.